You spend time and money setting up a living trust, but if you never transferred your assets into it, that trust might do nothing when it matters most. And when your family finds out, it is often too late to fix it without a court proceeding. In this video, I will walk you through exactly what funding your trust means, why it matters in California, and what could go wrong if you skip this step. So your estate plan actually works, your family avoids probate, and you don't leave behind a legal mess that no one wants to deal with. Hi, I'm Talai, a trust and asset protection attorney and founder of Talai Law Offices. I recently started creating videos on social media with the goal of providing educational content that helps individuals and families make more informed decisions about estate planning, asset protection planning, and preserving their wealth for generations to come. I am passionate about helping clients create estate plans that protects their legacy and not just makes distribution of their assets. Estate planning is full of legal nuances that can impact both your family and your financial future. And if you want to dive deeper, I invite you to join my free webinar, Avoiding the 5 Biggest Estate Planning Mistakes. You can register at talailaw.com. That is my website, under the events page, or just use the link in the description below. My clients often ask me, I set up my family trust, isn't that enough? And my answer is always, not unless you fund it. Funding your trust means transferring ownership of your assets into the name of the trust. It's not an automatic process when you sign the trust document. Your assets don't just automatically transfer. You got to make sure you transfer them. Sometimes we use deeds, sometimes we use other ways and means to connect the assets into the trust. Think of your trust as an empty safe. You have to put your house, your bank accounts, investment accounts, and other assets into the safe for it to actually do its job. In practical terms, funding involves changing titles and deeds. For real estate, your home, your investment property, we would want to record a deed, usually a grant deed or sometimes a quitclaim deed, to reflect that now your trust is the owner and you're not the owner anymore, that your trust is the owner. That's the key. For bank accounts or brokerage accounts, updating the account ownership to the trust would be very, very helpful, and that's probably the best way to do it. If you just sign a trust agreement, but everything you own stays titled in your personal name, your trust is essentially an empty shell. All right, so let's talk about why funding your trust matters so much, especially in California. California's probate process is famously expensive and time-consuming. One big reason people create living trusts is to spare their family from the ordeal of probate court when they pass away. A properly funded trust lets your heirs manage and inherit your properties, your assets, without delay and cost of probate. But if the trust isn't funded, those assets still have to go through probate as if you never had a trust at all. Talking about expenses, let me give you an example. California's statutory probate fees are based on the gross value of the state. So if you own a house that is $1 million, it doesn't matter that you had $800,000 lien on the property, mortgage on the property. The probate fee is based on the gross value. A $1 million estate would incur about a minimum $23,000 in attorney fees, another $23,000 in executor fees. That is roughly about $46,000 just in fees. And believe it or not, this is the minimum statutory fee. And this does not include the additional court costs and the 1 to 2 year your family might spend tied up in court. There's also the matter of control and incapacity planning. If your assets are in your trust and you become incapacitated, then your hand-picked successor trustee, he or she can step in and manage those assets for your benefits without having to go to court. But if you forget to fund your trust, and everything still is in your personal name, unfortunately, at that point, your family would have to go to court. They would have to try to set up a conservatorship so that through the conservatorship, the assets could be managed. By funding your trust, you're ensuring your loved ones can skip the headache and maintain control. There is also the matter of control and incapacity. If your assets are in your trust name, they're titled, they're owned by the trust or connected to the trust in some shape or form, and you become, unfortunately, incapacitated, mental incapacity, your hand-picked successor trustee can step in and manage those assets for your benefit. But if you forgot to fund the trust and everything is still in your personal name, your family has to go to court to set up a conservatorship to manage those assets. By funding your trust, you're ensuring your loved ones can skip the headache and maintain control if something happens and you become incapacitated or when you have unfortunately passed away. So what if you set up a family trust, but you never actually funded with your assets? The honest truth is that the trust will have no effect on those assets. They remain in your individual name. When you pass away, the assets that should have been in the trust will be treated as part of your estate, not part of the trust. The result, likely probate or other legal hurdles. Most estate planning attorneys, myself included, prepare a backup pour-over will for this exact situation. A pour-over will basically says any assets I forgot to put in my trust during my life should be poured into the trust when I pass away. It is a safety net, a spare tire sort of a thing. But just remember, the pour-over will does not automatically transfer assets that you forgot and left outside the trust into the trust. It is not an automatic thing. Your kids, the executor, somebody from your side would have to go to court and get a court order that allows the property to be transferred into the trust. So it's truly a backup plan. That is not something you want to rely on when you're setting up your estate plan. You want to make sure you make the transfers while you are here. All right, let me give you an example. Not too long ago, I had a client whose parents set up a living trust and they listed their daughter, my client, as the successor trustee to manage everything when they have passed away. The parents fully intended to transfer their home into the trust, but somehow that step never happened. The property was never transferred into the trust. Years go by, and when the parents passed away, my client went to sell the family home. Only then she realized that the home was still titled in her late parents' name, not in the trust name. As the successor trustee, she then discovered she had no authority over the house because the trust didn't own it. Unfortunately, she couldn't just take the trust document to the realtor or the escrow company and sell the house. We had to go to probate court to get authority to transfer the home into the trust. And then she had the ability to list the property and sell the property and sign all the documents that were required. And this is exactly the kind of scenario we want to avoid by making sure we fully fund our trust and not leave it to the pour-over will. So the question could be now, can you fix an unfunded trust after the person has passed away, after the grantor passed away? In California, there is a possible remedy, but it is essentially a trip to the court, and it's not guaranteed to work in every case. We have what is called a Heggstad petition, named after a 1993 California case, a state of Heggstad. In that case, Mr. Heggstad had listed a piece of real estate on the trust schedule of assets, but never actually signed a deed transferring that particular property to the name of the trust. The court held that a written declaration of trust by the owner naming himself as the trustee for that particular property was sufficient to create a trust in that particular asset. No separate deed was required. Following that case, California law was updated. Now, Probate Code Section 850 allows a trustee, like your successor trustee, after you've passed away, to petition the court to transfer assets into the trust that were left out if they can show those assets were meant to be in the trust. We commonly call this a Heggstad petition. For example, if your trust document or attached schedule explicitly lists your real estate, your home, as part of the trust assets, but for some reason you don't get a chance to quitclaim it and transfer it into the trust, the court can order that house to be placed into the trust through this petition. California courts have also accepted general statements in the trust like, I hereby transfer all my assets into the trust as evidence of intent to fund the trust. It is incredibly important to make sure the trust you have prepared for you is comprehensive and it has these provisions, these general statement of intent, making sure the schedule of asset is completed. It would extremely be helpful if something happens and you pass away and for some reason part of your estate is not transferred into the trust. We can use 850 petition, Heggstad petition, to be able to transfer these assets into your trust. It's still not the preferred way, but it's much better than having your children, having your beneficiaries go through a year or 2 years of probate. Now, all of this might sound like a lifesaver, and it can be, but I want to stress that this is really just a backup plan, not something to rely on. You're still involving attorneys and the court, which means delays and legal fees. It is always better to do things correctly now rather than ask a court to fix it later. Think of a Heggstad petition like an emergency brake. It is there if you need it, but you're not going to be driving around with it the entire time. Since you're hearing this in time, meaning you are alive and just realizing your trust is not funded properly, the good news is you can likely fix it without any court involvement. It is much easier to handle while you're alive. You can retitle your assets into the trust with the help of a qualified attorney. So if you were to ask me how to avoid this unfunded trust problem, the simplest advice I would give you is that once you create your trust, work with your attorney to create a checklist of all your major assets, real estate, bank accounts, a stock, business interest, and so on, so that you can figure out how each asset is to be transferred into the trust. For example, real estate, that you will use a deed. You would need to use a deed that would transfer the property from your name to the name of the trust. Luckily, California has property tax reassessment exemption for transfers into a revocable trust, so don't worry about property tax hikes. For bank and investment account, it often means filling out the instruction forms to change the account owner to the name of the trust, or at least naming your trust as the paid on death beneficiary of that particular account. Also, update beneficiary designation form where it's appropriate. Certain assets like insurance or retirement accounts might not be retitled to your trust during your life, but you may name the trust as the beneficiary if it aligns with your estate plan. It is also wise to set up a routine review, let's say every 3 years or whenever you acquire a new significant asset. Ask yourself this question: does this new asset need to be in my trust? If you don't know the answer, then you call your attorney. For instance, if you buy a second home, remember to deed it into the name of the trust right when you're purchasing the property in escrow. If you open up a new bank account, considering titling the bank account under the name of the trust from the get-go. If you create a new entity, a corporation or an LLC, make sure you name your trust as the shareholder or the member of that particular entity. By staying proactive, you ensure your trust remains fully funded as your life evolves. To recap, setting up a trust is a fantastic step, but it's only step one. Funding that trust is what actually makes it work for you and your family. If you forget, the court have ways to transfer and connect your assets to the trust, but those ways cost time and money and stress, the very things you wanted to save by using a trust. The truth is, a trust that isn't funded is like having a car without any gas in it. It's not going to get you very far. Now you might be wondering what other tools are out there to protect your family's assets. A living trust is great for probate avoidance and basic estate planning, but it does not by itself protect against every threat. In my next video, what is a family holding company and should you have one, I'm going to explore a powerful strategy that some families use to level up their asset protection and control. If you are serious about safeguarding your wealth, especially here in California, where lawsuits are not uncommon, you wouldn't want to miss it. See you over there.